Welcome back. I'm Vincent Perryman and you're watching Legalese. Joining us on our show is local attorney Angela Lawson, and we are talking about conservatorships. Angela, before the break, we were kind of banding around about conservatorships, some of the pros, the cons, very general in that. You know, we mentioned different terms such as a conservator, a guardian ad litem, an award, and I think it's always useful to, now that the audience has heard these several times, to break it down and define what each one of these are before we go into the actual steps of what it takes to do a conservatorship.
Right. Well, the first is the conservator, and that is the person that is going to be in control and manage the health care and the finances of the ward. So the ward is the person that you're seeking a conservatorship over. So they have some sort of disability. It can be Alzheimer's, dementia. It can be some sort of mental instability like bipolar disorder or some sort of psychotic issue that, so it's not necessarily always the elderly that you would do this. And then the third is guardian ad litem. And that is the third party that the court will appoint to come in and kind of evaluate the whole situation. They'll meet with the ward and the conservator and review all of the finances and make a recommendation to the court as to whether or not the conservatorship should go forward.
And under the statute, there's also a thing called an ad litem attorney, which can be appointed specifically to represent the ward, especially if you've got a situation where your ward is coming in going, I don't need a conservatorship. And then the other thing to note, I think, about the conservator itself, that's something that's going to be decided by an order of the court as to who is conservator.
Right.
So when they originally start the action, they're petitioning to be a conservator.
Correct.
So let's talk about how you start the process.
Well, you would want to meet with an attorney to help you go through this process because it is a court process. There's a hearing and everything involved. So once you meet with the attorney, they'll help you draft a petition that gets filed with the court. And that petition has several requirements. You have to allege some sort of incapacity of the person that you're trying to get a conservatorship over, whether it's dementia, Alzheimer's, or whatnot. And then you also have to tell the court what type of conservatorship that you're seeking. There's limited conservatorships, which would be if someone just needs help with either the financial aspects of their life or if they need their just help with their health care. So you can have it limited, or if you're going to get a general conservatorship, which is more common, which is over both the health care and the finances of the person. So those are things that you have to allege in your petition that you file with the court. Also, along with that petition, you have to have a physician's affidavit, and it has to come from a doctor. It has to be a doctor. A nurse practitioner it is not good enough under the statute in Tennessee. So it has to be an MD that has examined the ward within, I believe it's 90 days of filing the petition. And in their affidavit, they state their diagnosis of the ward, whether if they have Alzheimer's or dementia or their incapacity or disability, and they make a recommendation. Yes, I believe that a conservatorship is warranted over this person, and so that also gets filed with the court. So that it can be, you have that doctor backing up. It's not just someone going in saying that you want a conservatorship. So once you have that filed, you've kind of started a clock running because you have 60 days to get to your final hearing. And in that 60 days, you have to have a couple things happen. You have to give notice. So you have to serve the ward with the papers, the petition saying that you're seeking a conservatorship over them. And then you also have to give notice to all the family members. So if they have a spouse, and you're not the spouse, obviously, then you need to give notice to the spouse and to any children that are of the ward so that they know that you're seeking this conservatorship over them. So if they want to object or if they want to join in even, then they have the opportunity to do so. And so once all that happens, then the court appoints, well, I guess the court appoints at the time you file the petition, a guardian ad litem, like we mentioned before. The guardian ad litem has an important role in conservatorships. They meet with the person that's petitioned to be conservator. They meet with the ward to determine if there is, in fact, some sort of disability and need for conservator. When they meet with the petitioner, they're trying to decide, is this the best person to serve as conservator? The petitioner might not be the best person. They might have a spouse or another sibling that is better served, and that's one of the roles of the guardian ad litem, to determine that. And so they also will do a review of the finances, because when you take over the finances, the court is very particular about making sure that you take care of the finances, and the finances are used for the benefit of the ward. So the guardian ad litem does a very careful review of all of the assets that they have, and they report that to the court also in their guardian ad litem report. So once all that's in, then you have a hearing before the court, before the judge. And in this hearing, the conservator or the petitioner will be there, and the guardian ad litem, and the petitioner gets put on the stand, and the judge, the attorneys, the guardian ad litem, and the judge all have the opportunity to ask questions to make sure that they understand their role. There are certain fiduciary duties that the conservator will have. It's to make sure that everything they're doing is for the benefit of the ward. And the judges are extremely careful to point out, especially with the finances, that all of the finances are to be used for the benefit of the ward. And so they really reiterate that when they put you on the stand.
And then after that hearing, basically there's an order that comes out.
Exactly.
And then your duties are ongoing as far as filing accountings and reporting back to the court as to what's going on with the ward. And then you also, as the fiduciary, you've got to make sure you're filing their tax returns and things like that. And in Shelby County, this all happens in probate court. In other counties, it happens in chancery. And we'll get into some more of that in our last segment here. When we return from our break, we'll talk more with attorney Angela Lawson about conservatorships. Please stay with us.